All right, hi, and welcome back. Attorney Steve Vondran, welcome to another exciting episode of Vondran Legal Hour. Okay, Attorney Steve Vondran here. So we're talking today in this podcast about work for hire contracts, or what they call work made for hire. Okay, work made for hire. Now, what is this? This is basically a copyright issue, okay? When you're hiring someone to do some work on your behalf, you want to make sure that you own the copyrights. Now, let me give you an example. Say you're going to create a documentary film, okay? You may have a writer, you may have an editor, there may be filmmakers, cameramen, voiceover specialists, editors, all this stuff. You want to make sure that when they're doing work on your documentary, that they're not getting the intellectual property rights, i.e. specifically the copyrights, okay? So what do? You get a work for hire or a work made for hire agreement with them. Okay, now this is, I see a lot of people talking about work for hire, and I think I think a lot of people think that anytime that you have a project, you just get a work for hire, and that means that you own all the rights, okay? It's not that simple. You got to make sure you understand the work for hire doctrine, okay? And you can find this in Section 101 of the Copyright Act, and this is 17, Section 101. Now, there are two instances where something created by another person becomes your intellectual property. Their work product becomes your property in two instances. One is if you have an employee working within the course and scope of their employment. So say you have a in-house video editor and that person is a W-2 employee and they work for you. That is a work for hire. That means anything that employee produces within the course and scope of employment is the employer's property. It's the employer's copyrighted work, okay? The employer can go and register it with the Copyright Office of the United States, okay? So that becomes an employer's rights. Now, some people will spell this out in an employment agreement or in the employee manual, whatnot, but this is in the law. It's in Section 17, USC 101, an employee within the course and scope. Now, the other one is what we're talking about here. Independent contractors. So these are the people, maybe you're hiring them on Fiverr or Freelancer, some freelancer site, this, that, and the other. When you're dealing with these companies, and I like Fiverr, by the way, but you always want to make sure that you're either getting a work for hire agreement in place or you're making sure that the rights are assigned to you. Now, this is where it gets confusing for a lot of people. Like I said, a lot of people think a work for hire agreement, just, anytime somebody signs it, you're good. It's your intellectual property, but not necessarily true. And this is how disputes can arise when let's say a writer, for example, says, what do you mean? My screenplay it's not covered in the work for hire doctrine. It's not covered. So why are you claiming that this work for hire agreement is valid? Let's talk about it. In essence, there are 9 categories that qualify for work made for hire. If it's not one of these 9, then your work for hire agreement is essentially worthless, okay? It's got to be one of these 9 or it's not a it doesn't come within the subject matter of the section on this, okay? There are 9 things, okay? Let's go over these. Let me take a close look here. 1, to a work that is specially ordered or commissioned for use. 1, as a contribution to a collective work. Okay, so this could be a contribution to a more collective work, such as a movie or something you're putting together, a play. And so a contribution to a collective work can come within the work made for hire, get a work made for hire agreement, good to go. 2, as part of a motion picture or other audiovisual work. Okay, this is what we're talking about, part of a motion picture or documentary. Let's say, yeah, the writer, editors, filmmakers, let's get your work made for hire agreements, let's get them in order. Number 3, as a translation. So if you have somebody doing translation work, that's work for hire. 4, as a supplementary work. The law defines a supplementary work as a work prepared for a publication as a secondary adjunct to a work by another author for the purpose of introducing, concluding, illustrating, explaining, revising, commenting upon, or assisting in the use of the other work, such as a foreword to a book, afterwords, pictorial illustrations, maps, charts, tables, editorial notes, musical arrangements, answer material for tests, bibliographies, appendixes, indexes, those kinds of things, okay? So a supplementary work, it's a pretty broad category. See if your work fits in there. So get a work made for hire contract, and that independent contractor's work will be your copyright, okay? Number 5, a compilation. 6, instructional text. 7, as a test. Somebody's making a test. 8, an answer material as answer material for a test. Or 9, an atlas. Okay, so as you can see, for example, I don't see producing software. I don't see producing software on this list, do you? So if you hire someone to create software for you, for example, it does not come within one of these 9 categories specifically set out as being able to qualify for the work made for hire doctrine, okay? So again, let's try to make this clear. When you're working with independent contractors who are contributing pieces, their work, their creative work, notes, music, sheet music, whatever, okay? When they're contributing, you want to make sure that it's a work for hire, okay? Now, I will tell you, in this day and age, like in California, for example, there's a lot of new legislation coming out, I should say, and I think it is out, that says, well, maybe you can't have contractors. Maybe everybody's an employee. So you have to be careful. You have to look at your state. You have to know what the factors are where we determine what an employee is versus what an independent contractor is. If everybody's an employee, I guess within the course and scope, you would automatically get the copyright, okay? If not, if they're independent contractors, make sure, if it comes within one of these 9 categories, make sure that you're getting a work for hire agreement. Now, if it's outside of one of these 9 categories, are you lost? Are you done? Do you lose your copyrights? No, you can still get them. And this is when I'm going to give you my story. I had somebody prepare a cartoon for me. I hired someone to create some legal cartoons off of Fiverr, Fiverr, one of my favorite sites. And cartoon did not come within this in the 9 works for hires. Drawing a cartoon is not one of these 9 items listed on works made for hire. So what I did, I created a contract with the person that I was hiring, and it was, it wasn't cheap to do this, but I made sure that there was an assignment of copyrights, Okay, this is where you get them to assign their copyrights. In essence, they're creating the copyrighted work. They hold the copyright, but they're assigning their work to you, and you put it in writing. Everybody signs it. You got the documentation. Now, your independent contractor, let's say they're creating the software for you, or they're creating a cartoon for you, or they're creating any other thing that doesn't meet one of these 9 items. Any other thing, you make sure they're assigning you the copyright. So in this case, I hired someone, created the cartoons. I can go and register the copyright in the United States Copyright Office, okay? That's how it works. Now, in a work for hire agreement, what you do, sometimes people aren't sure and they want to try to cover their bases. One common trick you may see in drafting these types of work for hire agreements, you may see work for a contract that's, doesn't have to be anything fancy. What lays out what the services are, the time frames, how you're going to get paid. In entertainment law, maybe credits getting credits sometimes is what you're looking for. Who's got the final approval rights? How many edits do you get? Is this an exclusive representation or is it non-exclusive? Those kinds of things. There may be indemnification clause. But regardless, you may see a clause that says, to the extent these works are not considered a work made for hire, the creator or the producer or the editor, whatever, hereby assigns all rights. So you see how you cover your bases. To the extent the works created are not deemed a work made for hire, all rights are assigned to the person who's doing the hiring. So they're assigned. That's how you cover your bases. That's how you get things going, and that's what you want to do. It's important when people are creating works. If you're a company and you have employees creating works, think about copywriting them. Competitors will steal them. You put things on the internet, people will copy them, those kinds of things. So you may want to copyright. If you copyright your works, you can be entitled to seek statutory damages, okay, by actually registering your copyright. So that's and attorney fees. So these can be sources of revenue when you find infringers, okay? But yeah, I mean, so that's a quick look at it. If you're working with somebody, make sure you know who owns the rights. When you sign up for these websites too, where you contribute your work, make sure you know who owns the rights. Like if you upload your music to a website, are they going to say, well, you didn't read the terms. We own your rights now. You didn't read that. So you need to be reading the fine print, as we say, but that is a general goal, overview, I should say, of a work made for hire under United States copyright law. Now, you can also assign trademarks and patent rights. Maybe somebody is creating software and they have a software patent. So you can have them assign all intellectual property rights, copyrights, trademarks, even trade secrets might even come up sometimes. But anyway, if you need more help with work for hire agreements, model and location releases, licenses, clearance, fair use opinions, work for hire agreement disputes, permits, life story rights, entertainment law, you know where to find us. Intellectual property, attorneysteve.com. That is attorneysteve.com. The first name in legal services. Now, thank you for listening today. We appreciate it. If you like this podcast, feel free to share it around. This is general legal information only. If you're not sure what the law is, obviously seek out legal counsel, especially when you have, big projects that are on the line. That's it. Thanks for listening, folks. Have a great day.